So a new case is up for Supreme Court review, and this one involves whether or not a state can ban people with nonviolent misdemeanors from ever being able to purchase handguns ever again. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again uphold our right to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, a case is now seeking Supreme Court review, and this case involves the state of Massachusetts ban on any individual who has been convicted of a non-violent misdemeanor that involves the possession of a gun from ever being able to purchase a handgun ever again. At the same time, the state permits the same person to be able to possess or use a gun and can obtain a license to possess a handgun at their home, but the state will not let the same person ever purchase a handgun. This case seeks review from the Supreme Court to strike down lifetime bans that prevent people with nonviolent misdemeanors from ever being able to purchase handguns. So let's talk about some of the background surrounding this case and then discuss the main arguments made in this petition to the Supreme Court. Petitioner Alfred Morin, who is a doctor, is a Massachusetts resident who in October 2004 traveled to Washington, D.C. with a handgun. At the same time, Dr. Morin had a Massachusetts license to carry a firearm, or essentially his concealed carry license. He did not know that the D.C. laws prohibited him from carrying his guns, despite the fact that he had a Massachusetts license to carry concealed. Mr. Morin went to the American Museum of Modern History, and at that time he saw a sign prohibiting firearms, and he decided to approach a guard to inquire about checking his handgun. Upon the police finding out that he had a handgun, he was arrested and charged with carrying a pistol without a license, possession of an unregistered firearm, and unlawful possession of ammunition. On November 8th of 2004, Dr. Morin pled guilty to attempting to carry a pistol without a license in violation of that DC code. In February of 2008, Dr. Morin submitted an application to renew his license to carry in Massachusetts. After learning about the 2004 misdemeanor convictions, the chief there in Massachusetts denied his renewal of his application. In February of 2015, more than 10 years after his guilty pleas, Dr. Morin then again applied for a license to carry concealed in Massachusetts. He was again denied because of these prior incidents. He then decided to sue for a deprivation of his right to keep and bear arms. A district court on review found that the right to carry outside the home is different from the core right to possess a weapon inside the home. Since it did not impact a core right according to the court found that as long as the restriction served an important purpose, that restriction was therefore valid. The district court found preventing potentially dangerous persons from carrying concealed weapons in public was an important purpose and therefore ruled against Dr. Morin. He then appealed that decision, and that went up to the First Circuit. The First Circuit ruled that there was no constitutional deprivation because a firearm identification card or a FID card, in conjunction with a permit to purchase, allows one to acquire a firearm and to possess it in one's home, and therefore he had the ability to exercise Second Amendment rights. Well, after the First Circuit's ruling, Dr. Morin then went to the state of Massachusetts to his local PD and submitted an application for a firearms identification card and a permit to purchase. However, he had his permit to purchase denied by the police department because of his prior misdemeanors, but they did grant his FID. After being denied his permit to purchase, Dr. Morin then filed another lawsuit, and in that lawsuit he claimed, without a license to carry or permit to purchase, he has no lawful method to purchase a handgun for use in the home for self-defense. The district court, in reviewing this new issue in this new case, decided to grant a summary judgment in favor of the Commonwealth of Massachusetts. So once again, they ruled against him. The court used intermediate scrutiny to reach its decision, which is a lower bar and a lower type of analysis. It kind of goes strict scrutiny, which is at the top, intermediate scrutiny, and then rational basis. The court found that individuals convicted of weapons-related offenses punishable by a term of imprisonment are not the type of law-abiding responsible citizens contemplated by the court in Heller. Therefore, they ruled because individuals convicted of weapons-related offenses punishable by terms of imprisonment are not, as a class, law-abiding and responsible citizens, the burden at issue did not implicate the core of the right protected by the Second Amendment, and intermediate scrutiny was appropriate. Also, the court denied looking at the law as applied to Dr. Morin. Now, some quick background on what they're discussing when it comes to as applied. In an as-applied challenge, litigants contend that a law is unconstitutional as it is applied to their specific situation. In contrast, facial challenges are where litigants claim that a law is unconstitutional on its face. The court here denied looking at the issue as applied to Dr. Morin in his specific situations. The First Circuit also stated that Dr. Morin was not outright banned from obtaining a handgun since he could inherit one if someone passed away. The court acknowledged that Dr. Morin was unable to obtain a handgun in any other manner. Specifically, he couldn't just walk into a gun store and purchase a handgun, but they found that inheritance and the potential that he could acquire a handgun through inheritance was enough. So that is the long, complicated mess and background relating to this case, and now this case is seeking Supreme Court review. The question presented in the petition to the Supreme Court is whether a state can impose a lifetime ban on purchasing handguns, but not possessing them, against anyone who has been convicted of a nonviolent misdemeanor that involved the possession or use of guns. The two main arguments made for why the Supreme Court needs to review this case is first, that the federal appellate courts are in conflict as to the extent of the government's burden to justify prohibitions on the right to keep and bear arms. And the second main argument that they make in this petition is that federal appellate courts are in irreconcilable conflict over the import of the presumptively lawful regulatory measures, and that's specifically referencing some language in Heller. In the first main argument section, the petitioner states, the resolution of this case highlights one of the most substantial conflicts that has arisen in the wake of Heller and McDonald. The actual rigor and scrutiny that a court should apply to laws that restrict the ability to keep and bear arms. Can the government justify a restriction that applies to a class of people by pointing to characteristics that apply to other classes of people, i.e., those who have been incarcerated, or to larger classes of people, i.e., anyone with a misdemeanor conviction? Or does the government need to justify the specific restriction at issue and show why individuals within it are particularly dangerous? This point here highlights an issue that has taken place all across the US. Various lower courts have applied different types of analysis when looking at different Second Amendment issues, including the rights of people with nonviolent misdemeanors and felonies. This inconsistency in analysis is something that the Supreme Court needs to finally address, and that is what is being argued here in this section. In the second argument section, the petitioner states, in Heller, this court emphasized that it did not intend to cast doubt on three categories of firearms restrictions, specifically 1, long-standing prohibitions on the possession of firearms by felons and the mentally ill. 2, laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. And 3, laws imposing conditions and qualifications on the commercial sale of arms. And then right after that language, the court actually had a footnote that stated that it identified these presumptively lawful regulatory measures only as examples and that their list did not purport to be exhaustive. In the wake of this language appearing in Heller, courts and various other lower courts have split all over the place, and they split over whether these presumptively lawful examples illustrate things that fall inside or outside the scope of the constitutional right to keep and bear arms. Here, the petitioner argues that the Supreme Court needs to resolve this issue created by their own language in Heller. So that is a rundown of what this case involves and the arguments being made on why the Supreme Court needs to finally hear this issue. So it's a weird case, really interesting facts. If we get any more information or an update, I will let you guys know. But I know a lot of people ask questions about nonviolent misdemeanor individuals, nonviolent felons, and this is one of those cases that seeks to address that issue. So if you guys have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I cannot thank you guys enough for everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought. So thank you so much for all of your support. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars. This nation will be maintained by armed scholars.